You just open your mail and there it is, an official IRS notice with a lot of numbers, a lot of legal language, and the claim that you owe tens of thousands or maybe even hundreds of thousands of dollars in additional taxes. Your heart is probably racing. You're thinking, this is it, the IRS has made its decision, I'm done. But here's what the IRS doesn't make clear in that notice. You just received one of the most valuable documents in the entire tax controversy system. That notice, it's called a Notice of Deficiency or a 90-day letter, just gave you something incredibly important: the right to challenge the IRS in the United States tax court before you pay a single penny. I'm Andrew Bosserman with Boss Tax Law. I'm a tax attorney, CPA, and a former IRS agent, and in this video, I'm going to explain why a notice of deficiency isn't the end of the world. In fact, in many cases, it's exactly what you want. So let's break down what this notice really means and why tax court access changes everything. First, let's talk about what you're actually looking at. A notice of deficiency, and it's also sometimes called a statutory notice of deficiency or a 90-day letter, is the IRS's formal determination that you owe additional taxes. This typically comes after an examination, an audit, or when the IRS has discovered unreported income on your return. The IRS will send out dozens of different types of notices. Many of them are informational or proposed changes, but a notice of deficiency is different. It's a statutory notice, meaning it triggers specific legal rights and deadlines. The notice will show the tax years in question, the amount of additional tax the IRS believes you owe, how the IRS calculated that amount, and your 90-day deadline to respond. You have exactly 90 days from the date on the notice, not when you receive it, but when it's actually dated, to respond. If you're outside the United States when the notice is issued, you get 150 days. This is a hard deadline. Miss it and you lose your most valuable option for fighting the IRS. So that 90-day deadline is extremely critical. If you don't respond within 90 days, the IRS assessment becomes final. At that point, the IRS can begin the collections process, which could include recording a federal tax lien against your property, levying your bank accounts, garnishing your wages, or even seizing assets. Because once that 90-day window closes, you've lost your right to challenge the assessment in tax court before paying. Your only option now is to pay the tax first and then file a refund claim, which means you're out of pocket potentially hundreds of thousands of dollars while you fight the IRS. Now here's where most people misunderstand what's happening. When you get a notice of deficiency, your first reaction is likely panic. The IRS has decided I'm being assessed, this is bad, but let me reframe this for you. The notice of deficiency is actually the IRS giving you a gift, the gift of prepayment judicial review. What this really means is that in the American tax system, the IRS generally has the right to assess taxes and collect them first, and then you can sue for a refund later. That's how it works in federal district court or the court of federal claims. You pay first, litigate later. But tax court is different. Tax court is the only federal court where you can challenge the IRS's determination before you pay a single dollar. That notice of deficiency is your golden ticket to tax court. Without it, you can't get in. So let's go through an example. Let's say the IRS claims you owe $300,000 in additional taxes. If you don't have access to tax court, you need to pay that $300,000 first, then file a refund suit, and then wait years to potentially get it back while your case moves through the system. But with tax court access, you can file a petition and pay a nominal filing fee, and suddenly the IRS can't collect while your case is pending. You get to present your case to an independent judge. You can negotiate with IRS attorneys from a position of strength, and you can keep your $300,000 in the bank while you fight. This is huge. For many business owners, keeping cash flow during a dispute can be the difference between staying in business and closing your doors. So think about this scenario. You could be undergoing an audit with the IRS, many months of back and forth with an IRS examiner who is just not going to budge on their position. The examination often drags on with no resolution in sight. But when you actually get your notice of deficiency, oftentimes you're relieved. Why? Because now there's a clear path forward. You know what the IRS is proposing to assess, and you can file a tax court petition, get assigned to IRS appeals, and finally have productive settlement discussions with someone who has settlement authority, unlike frontline IRS agents who generally follow the letter of the law. That notice of deficiency ends the uncertainty and opens the door to resolution. When you receive a notice of deficiency, you essentially have two paths. Option one, you can agree and pay. If you review the notice and you agree with the IRS's determination, maybe they're right, you did underreport income or claim deductions you weren't entitled to, you can simply sign the waiver form that comes with the notice and arrange payment. If you can't pay the full amount, you can set up a payment plan and explore other collection options like an offer in compromise. This option of agreeing with the notice of deficiency makes sense if, say, the is correct and you have no valid defense. Maybe the amount you owe is relatively small and not worth fighting, or you made an honest mistake and just want to resolve it. But oftentimes, you are going to disagree with the IRS determination, and that's what option two is. You disagree and file a tax court petition. If you disagree with the IRS's determination, whether it's the facts, the law, or both, you file a petition in United States Tax Court within that 90-day window shown on your notice of deficiency. Filing that petition accomplishes several critical things. First, it stops the IRS collection process. They cannot collect the tax or assess it while your case is in tax court. Second, it gets you out of the examination division and into the appeals and litigation process. Your case will first get assigned to IRS appeals, which has settlement authority that the examining agent didn't. And finally, it gives you leverage. The IRS knows that if they can't settle with you, they're going to trial, and that costs them resources, time, and carries risks. Tax court also preserves all of your options. You can still settle at any point, and filing the petition doesn't mean you're actually going to trial. In fact, the vast majority, over 90% of tax court cases settle before trial. Technically, you can file a tax court petition yourself. The tax court has forms on their website, and many taxpayers do represent themselves. And that's called representing yourself pro se. But here's one thing you need to understand. Once you file that petition, you're going to be dealing with IRS attorneys. These are lawyers who represent the IRS in dozens or hundreds of tax court cases every year. They know the law, they know the procedures, they know the judges. When you file a tax court petition, you're not just simply checking a box on a tax return. You're making strategic decisions that will impact your entire case, like how do you frame the issues, what facts you emphasize or de-emphasize, how do you respond to any IRS discovery requests, when do you push for trial versus negotiate, what legal arguments should you raise, and how do you value your case for settlement purposes. These decisions matter. And I've taken over cases where either taxpayers or a different representative represented them for months, and by the time they came to me, you're often dealing with trying to fix issues they may have created by trying to handle it themselves beforehand. So let's say the IRS claims you owe $200,000. You might be thinking a tax attorney is going to charge me $30,000, $50,000, even more. I'll save money by doing this myself. But if representing yourself results in paying $200,000 instead of settling for $75,000, you didn't save money. You just lost $125,000 by trying to save $50,000. Oftentimes, there's a return on qualified representation in tax court. And it's often helpful to think about it that the attorney's fees isn't an expense. It's an investment that typically pays for itself many times over. In fact, attorneys at Boss Tax Law, oftentimes when we're representing taxpayers in tax court, we will charge a contingent or a success fee, meaning a portion of the fee is only payable if we're able to get your taxes reduced or eliminated. But there are limited scenarios where pro se representation might make sense. Let's say your case is very small by tax court standards. That would be, say, under $10,000. the facts are really clear cut in your favor and you feel like you can handle it yourself, or you have significant legal experience and comfort with legal procedures. But for business owners, businesses with substantial amounts at stake, professional representation is, pretty much essential. And here's also something that might surprise you. The IRS wants to settle most tax court cases. Going to trial is expensive for the government. It ties up IRS attorneys. It may require witness preparation. It also carries risk. The IRS knows they don't win every case, and even when they do win, it might not be worth the resources expended. Once you file your petition, your case will get assigned to IRS appeals if you haven't had a chance for appeals review before. These are experienced settlement officers who have the authority to look at the hazards of litigation, meaning the risk that the IRS might lose at trial, and make settlement offers. This is completely different from dealing with the examining agent during the audit. The examiner's job is to enforce the tax code as they see it. They have very limited settlement authority. In fact, really no settlement authority. But appeals can settle cases based on hazards of litigation, potential evidentiary issues, witness credibility or what kind of witnesses you'd bring up, legal precedent uncertainty, and all sorts of practical considerations. So, with that being said, if you received a notice of deficiency, here's exactly what you should do. Step 1, check the date on the notice. Look at the date on your notice of deficiency, not when you received it, but the date printed on the notice. Count forward 90 days, or oftentimes it'll show the 90-day deadline, and that's your absolute deadline. Put it on your calendar, set multiple reminders. You can't miss that 90-day deadline. Step number 2, don't panic, but also don't wait. You have 90 days, but don't wait until day 89 to take action. Tax court petitions need to be prepared carefully, and you need time to gather documents and evaluate your position. Step number 3, gather your documentation. You'll want to pull together a copy of the Notice of Deficiency, your original tax return for the years in question, any other correspondence you've received from the IRS, any documents that support your position, things like that. Step 4, you're going to want to consult with the tax attorney. So most tax attorneys who handle tax court work will offer a consultation where they review your Notice of Deficiency, evaluate your case, and explain your options. This consultation should give you an assessment of the strength of your position, a realistic range of potential outcomes, an understanding of what representation would cost, and a clear recommendation on whether to fight or settle. And finally, step 5, file your petition. If you decide to challenge the IRS's determination, your attorney will prepare and file the tax court petition before the 90-day deadline. This is critical. The petition must be filed, meaning postmarked or electronically filed, within the 90-day window. 1 day late, and tax court has no jurisdiction to hear your case. So in conclusion, a notice of deficiency can feel like the worst news in the world when you first receive it and open that envelope. But now you understand what it really is. Your pathway to independent judicial review before you pay the IRS a dime. This notice gives you options. It gives you leverage. It gives you the opportunity to fight back on a level playing field with an independent judge deciding who's right. Don't let that 90-day window pass. Don't let fear or confusion cause you to give the most valuable right you have in the tax controversy system. If you've received a notice of deficiency and aren't sure what to do next, reach out to us at Boss Tax Law. We handle tax court cases throughout the country, and we can evaluate your situation and explain your best path forward. And remember, a notice of deficiency isn't the end. It's actually the beginning of your chance to fight back and win. So thanks so much for watching, and I'll see you in the next video.